Tennessee Firearms Association is tracking 53 bills this year in the legislature. But there are three in particular that seem to be getting the most attention in the news media and the most discussion in social media. And those are the three bills that bring up the possibility of Tennessee joining the 18 other states that already have adopted what's commonly referred to as constitutional carry. And I want to back up a minute and just give some background on what that concept really is. When I started doing this in 1995, there was one state in the nation that allowed its citizens to carry a firearm without the requirement of having to have a permit. That was Vermont. Back in the mid-90s, we always referred to this as Vermont-style carry. Since then, 17 other states have adopted constitutional carry. 30 states, or 31, depending on how you count them, have adopted permitless open carry. And for our purposes tonight, and for purposes of what Tennessee Firearms Association is doing with the legislature, constitutional carry has a very simple definition. It's a concept that says any person who can legally possess a firearm is able to carry that firearm without the requirement of a state-issued permit. That is not the same thing, however, as permitless carry. Permitless carry is something that we've had for a few years here in Tennessee under certain limited circumstances. And it's what some other states have with conditions. Permitless carry is a situation where, as we adopted in 2014, a person may be able to carry a firearm or possess a firearm without the need for a permit. Those typically have some restrictions on them that constitutional carry does not have. For example, when Tennessee adopted permitless carry, it was a vehicle transport statute. So for the last 7 years in Tennessee, we've been able to have firearms that are legally possessed in motor vehicles that we legally possess without the requirement of a permit. And that includes loaded or unloaded. It includes handguns, rifles, shotguns, anything that meets the definition of a firearm. But permitless carry is not constitutional carry. Permitless carry always has some categories of infringements on the rights. Constitutional carry basically goes to the full scope of the Second Amendment and says legal possession of a firearm equates to the ability to carry the firearm. So with that background, Tennessee has 3 bills pending this year on permitless or constitutional carry. The bill that's most likely to fit the definition of true constitutional carry is House Bill 1388, Senate Bill 1391. It's carried by Representative Chris Todd and Senator Janice Bowling. And what it does is it simply deletes the statute, the sentence in the statute that says it's a crime for someone to carry a weapon with the intent to go armed. It leaves the remainder of the statute intact, but it simply deletes the prohibition on the average everyday citizen from carrying any firearm. It therefore meets the definition of any legal possessor, and it meets the definition of any legal firearm. The second bill that I wanted to mention is House Bill 18, Senate Bill 318. That's Representative Bruce Griffey and Senator Joy Hensley's bill. What it does is it creates an exception to the crime of carrying with intent to go armed. But the exception is written just like the vehicle transport exception a few years ago, and it says any legal weapon that is possessed by anyone who can legally possess a weapon. It goes one step further, however. This is an important difference with House Bill 1388. Griffey's bill says if you're carrying pursuant to this exception, which would be subpart G of the bill, then that's equivalent to having an enhanced handgun permit in Tennessee. That is a very significant addition in that bill, because if we adopted some form of constitutional carry or permitless carry, and we don't deal with prohibited places like public parks, greenways, vehicle transport when you commute to work, all of those other statutes require that you actually have a permit to be an exception to the rules. Griffey's bill addresses that, and Todd's bill, the first one I discussed, does not. And that's one reason we have a favorite or a favor towards Griffey's approach, even though it leaves the prohibiting statute on the books. The third bill, and the one you've probably heard the most about if you're watching the news, is House Bill 786 by Representative Lamberth and Senate Bill 765 by Senator Jack Johnson. And this bill is commonly referred to as the governor's bill.
Excuse me, I have 24 and 12.
I'm sorry? The governor's bill. It's literally the worst of the three bills. It starts off with the proposition that it would only apply to those 21 and up. It does have a provision on it that says it would allow 18 to 20-year-olds who are either in the military or discharged from the military to be eligible, but it excludes all others in the 18 to 20-year bracket who can otherwise legally possess handguns or long arms. The governor's bill only applies to handguns. It imposes a restriction that the Second Amendment clearly does not impose. It has a curious provision on it that we still don't have a straight answer on. It says you have to be in a place where you're legally entitled to be. That to me sounds like a trap, particularly when the sponsors won't explain to us why it's there. Then the governor's bill adds at least three categories of restrictions that are not found in the Gun Control Act. One is stalking. They make a big deal about stalking, and federal law prohibits people who have stalking convictions coupled with orders of protection from possessing firearms, but not just a stalking conviction, because those are typically misdemeanors. This bill, the governor's bill, goes further, and it imposes, if you have a stalking conviction, what is essentially a lifetime ban unless you have that reversed or expunged. The governor's bill also has a DUI provision in it. And currently the DUI provision says if you've had one DUI within the last 5 years or two DUIs within the last 10 years, that you would be prohibited from carrying a handgun without a permit. Then the third element is one on mental health. And federal law currently does have a provision that prohibits people who've been adjudicated mentally defective, who've been committed to an institution, or who have been found not guilty by reason of insanity to be prohibited from possessing firearms. But there's an element of federal law and current state law that the governor's bill omits. And that is, as a result of a change in federal law in 2008, states have to impose or create a statutory process where someone who's had a mental health committal or a mental health finding by a court to be able to go back in front of that court after 3 years have passed with adequate medical proof and have that disability relieved. So while federal law with respect to purchasing firearms or possessing firearms has a relief of disabilities mechanism for people with mental health issues, the governor's bill does not. And then the final observation on the governor's bill is it's not even really just a permitless carry bill. It is primarily a $17 million a year crime package that's going to be a recurring expense for Tennesseans, and neither of the other two bills have that crime package price tag on them.